Have you lost a loved one? Was a loss preventable? Were there complications with your child's birth? Does your child need specialized care? Call Rufo Law Group for a free record or document review and case evaluation. Call 852-RUFO today. That's 852-7836. Or visit rufolawgroup.com.
Welcome to the Legal Advice in Paradise podcast, brought to you by www.legaladviceinparadise.com. Even in one of the most beautiful places in the world, life can be litigious. On this podcast, the best and brightest legal minds gather to help you navigate your way through every legal question you may face. This program will help you know your rights, know what steps to take, and help you find the best legal representation, all in simple, easy to understand terms. And now, here's your host, Justine Gronwald.
Aloha, Agents of Change. This is Justine with Legal Advice in Paradise. And today I have the honor to be with Mr. Jeff Portnoy. And he's with Cades Schutte. And previous episode, we had Mr. Martin Shaw as a guest. And so we have the honor of having another partner at Cades Schutte.
One of the oldest.
Oh, so I'm going to talk about that because you are a partner practicing in the area of litigation.
Yes.
And you chair the firm's litigation department. So you are very active in the court. You're out there.
Been around a long time, 42 years.
Yeah, it says since 1972. And you have extensive litigation in alternative dispute resolution in several areas of substantial law, which includes insurance, employment, mass tort, product liability, media, securities, and medical and legal professional errors and omissions. That's a mouthful. And you were president of the Hawaii State Bar Association in 2007.
Yep.
So you work really closely with all the attorneys, new ones that are coming in, also the ones that are, have been around for a while.
That's part of the job as bar president, yes.
Mm-hmm. That's a big responsibility.
Yeah, it was a fun year.
A fun year, okay. So we're here today, actually. We're going to talk about medical malpractice. Now, prior to me setting up this podcast, people, ask me questions about that. And of course, I'm not the legal expert, and that's why I interview people like you. I want to start off with one question that people probably have in mind first and foremost is, how do we recognize that we have a valid, medical suit to begin with? I mean, what constitutes someone with a valid complaint or injury? What validates that? Before they come to you, what should they know?
Well, ultimately, to prevail in a case of medical malpractice, you have to prove that the physician or the healthcare provider has breached the standard of care. And the standard of care is generally measured by what would a competent physician in the same situation have done or not done. And it's a national standard most of the time. It's not a local standard. So what you have to do if you're going to be a plaintiff or a claimant in pursuing a case against a healthcare provider is you're going to either have to have knowledge on your own, which is very unlikely that the doctor has not performed as expected, or you're going to need an expert to tell you that, some other physician who's going to review the records or what occurred and give you a preliminary opinion that the doctor has breached the standard of care. There are many ways of doing that. Most of them are somewhat expensive. But what's important is simply because the result is not what you expected, is not what you need to prove. You can have an adverse result many times, or at least a result that's unexpected, like a complication, but it doesn't mean that the doctor has acted negligently or has not performed as another competent physician in the same specialty would have done.
Yeah, because I think that's the first thing. I think, I turn this ringer off, I'm sorry. Oops. I think people need to differentiate that. Say they got treatment for something and it wasn't the result and they had all these adverse reaction. First thing, they're suffering, of course, they're in pain, and they're like, wow, this doctor did me wrong diagnosis, maybe the wrong medication, just a wrong reading. Does that constitute a valid suit against a doctor?
It really depends on the circumstances. I mean, it's a factual analysis based upon a professional evaluation, and many times there are experts on both sides. One expert saying, yes, this doctor breached the standard of care, and another expert saying, no, the doctor performed appropriately, and then it's left up to the fact finder, whether it's the jury or the judge, to make a determination as to whether there has been a negligent conduct that rises to the level of damages. You also have to prove that you've been damaged. Sometimes there can be a negligent medical act, but you haven't been damaged, or you would have had the same result even if the care had been appropriate. So it's multi-level. It's very difficult to actually say this is the way it is or that's the way it is. But there is an administrative procedure that's required before you can even file suit in Hawaii. You have to bring a claim before what's called the MICP, and it is kind of a mediation that's required as what I call a road bump or a speed bump before you can actually file a lawsuit, in which a lawyer and a doctor who are selected by the state will listen to both sides informally and see if they can bring about a resolution. But you can't bring a lawsuit alleging a medical tort unless and until you've gone through that procedure. They don't make a finding. Those two individuals don't say, yes, there is medical negligence, or no, there isn't. But you still have to go through that procedure. And one of the things you're supposed to do if you're bringing that claim is have your claim reviewed by an expert who will say, based upon what I see, I think you have the potential for a legitimate claim. So there are lots of things that should be done before people just try to go ahead and bring a medical negligence claim, because frankly, they're very expensive, they're very time consuming, and they're not all that easy to win.
Now, you talked about bring it to an expert. Who are these experts, and
they're
where
all over the place.
I mean, how do you find them? Do they have a title?
No, I mean, there's lots of different ways. Many of them have websites. You go on the internet and you can plug in the information. I need a expert in a medical negligence case in cardiology, and there's a bunch of people around the country. Doesn't mean they're any good. But they're advertising. You can ask friends. You can ask other doctors that you may know. There's lots of different ways. Or you go to a lawyer, and if the lawyer is experienced in representing patients, he or she will know where to go to get that kind of review. But it's not something you can just do on your own. In fact, what I mean, you can't just say, oh, this result is bad. I went in the hospital for 2 days and I wound up being there for 10 days. So somebody must have done something wrong. It's a lot more complicated than that.
So if somebody calls you, say they Googled and they came up with your name as representation. Now, you just told me something I didn't know, that you have to go through a pre-thing prior to even trying to file a lawsuit. I think a lot of people...
It's called the Medical Inquiry Conciliation Panel, MICP.
Say that again?
Medical Inquiry Conciliation Panel.
Wow.
And it's through the Department of Commerce and Consumer Affairs, and they administer the program.
I see.
So you have to file a claim there or a inquiry there, and then they have this couple of hour meeting with all the parties, and then if it doesn't get resolved, then you can go ahead and file suit.
So when people call you, they probably don't know this little fact or this huge fact, and then you direct them in that
Well, they don't call me because I represent doctors. So I'm defending doctors and hospitals.
Okay.
But I'm giving the procedure for people who want to bring a claim.
Right.
And you can look in the yellow pages. There'll be lawyers who do this. I would frankly not do that. I would ask around. There are a handful, and I mean a handful, of very skilled plaintiffs, medical malpractice lawyers who know what they're doing, who know how to evaluate a claim to see whether there's potential merit.
If it's frivolous.
Right.
Right.
And, as I say, they're very expensive. These experts can cost tens of thousands of dollars.
And this is before you hire an attorney.
Well, you want to get an attorney right away. I mean, some people bring these claims at least before the MICP without a lawyer. And you can do that. I still think it's best to have a lawyer, but you can bring the MICP claim, what we call pro se, on your own. But I would never encourage anyone to bring a medical negligence suit in court without proper representation. It's a minefield.
Wow, so this is more complex than most of us would even imagine. I mean, and I gather, especially what comes to mind for me is the growing population of elderly. So I'm pretty sure, well, maybe not, adult children, when they see their parents suffering and they want to say, hey, this was the negligence of the doctor or whatever,
Whenever
do you see a lot of that happening?
Well, that's elder care stuff. No, I don't see a lot. I'm sure it goes on. And those claims are sometimes brought against the assisted living facilities. But, look, people go to doctors every day. Not always does it end up the way they want. Or a family member. Sometimes people are just unhappy with their physical condition or their mental condition, and they're looking to blame somebody. So the doctors are targets, and they know that. That's why medical bills are extensive as they are, and why malpractice insurance costs as much as it does, and why doctors are getting out of the profession, because they're targets. And medicine is not it's kind of a combination of science and art. I mean, nothing is guaranteed, and so lots of people every single day are unhappy with a nurse or a doctor, and they are looking to blame somebody. So there's a lot of reasons why people think they have claims, but I will tell you that when you look at how claims end up, some settle, but many doctors will not settle, so they go to trial, and it's a very iffy proposition. The only thing I can say is it's time-consuming and very expensive. But in the proper case, they're worth pursuing. But just because somebody, for example, fractures a finger and they don't think it's healed fast enough, you have to evaluate what the damages are.
Right. I was going to address
that. If it costs you
$50,000
$50,000 to win $10,000, it's not worth it.
Right. So that's where I was going to ask you a question about claims. I mean, and I know it varies, what people think the injury is worth, like time spent out of work because of it, or just mental anguish, or they can't get around. I just came across someone who sent me a message and said he has a case. He didn't tell me any of the details, but he said that he's been talking to attorneys and they won't take his case. So many times, how do you see this? I mean,
as I said, they won't. I mean, the good lawyers, the ones that know medical negligence, know what it costs, and know what the difficulties are in proving the case, and how expensive and time-consuming it is. They won't take a lot of cases where people come in and say, well, I've been damaged, either because there's no negligence, or it's going to be really expensive and difficult to prove negligence, and at the end of the day, the damages are not going to pay for what it cost. But, there are always lawyers out there that are learning or might be willing to take a flyer on a case. But again, I want to point out there are some very significant errors in cases in which there are huge damages. A failure to diagnose a breast cancer, which leads to metastases and death, or a death during a surgery where there's been a serious mistake by the anesthesiologist. Those claims can be worth millions of dollars, and there have been $1 million settlements in Hawaii over the last several years. So they're out there, but I can tell you from doing 100 of these, many times people are bringing cases that either, one, they're not going to be able to prove, or even if they prove it, they're going to wind up spending more than they're going to get.
Right. And I take it that this is not like your typical personal injury. They will not do it on a contingency basis.
Yeah, they will.
They will?
Yeah, sure. Plaintiffs' lawyers do them on contingency basis. They're handled similarly, but the expenses are huge.
To get an expert witness.
Yeah, I mean, if you're in a car accident and somebody rear-ends you, that's pretty straightforward. You may need an accident reconstruction expert, but so what? But if you're in a case against a hospital where there are 7 or 8 different doctors who may have seen the patient, you're talking $100,000, $200,000 in expert fees.
Wow.
Because you have to get the right people. You can't get some quack who practices in the middle of Montana, on his own or her own. In certain cases, you need to get world's experts in certain fields to be able to establish the breach of the standard of care. And 1, they're not easy to get, and 2, they're not cheap. So it's the kind of thing where one needs to be fairly certain that they can prove the breach of the standard, that the doctor did not perform appropriately, and 2, that at the end of the day, you're going to recover more than it's going to cost you to prosecute it.
Yeah. Is there anything else that you would ask people, or tell people? Because obviously you're not for the plaintiff, you're for the defendant. What would you recommend, though, for people?
Well,
I mean, say they went into the hospital, had a procedure, and now they're in great pain. I mean, that's just part of,
I don't think pain. I think what people need to consider is, first of all, and I've said this before, a bad result does not translate necessarily into a legitimate claim.
Okay, I think that needs to be clarified.
A complication does not necessarily translate into a breach of the standard of care.
Okay.
A reaction to drugs doesn't necessarily translate into a breach of the standard of care. There are lots of things that occur that are known. I mean, if you go into a physician, and let's just talk about a surgeon, anybody that's gone, they will get a list, hopefully. This is another area called informed consent we can talk about in a second. They'll get a list of all the possible bad things that can happen. I mean, whenever you have anesthesia, you can die.
Right. There's
even if it's done appropriately, it happens. Now, there can be a mistake which causes you to die, then it's a claim. But the fact that you die or a relative dies, I don't make light of it, it's a terrible thing, doesn't mean that the anesthesiologist made a mistake. Now, the other area of claims against healthcare providers does not require an expert and does not require you to prove a breach of the standard of care, and that's the whole area of informed consent. Informed consent means that a physician informs you appropriately about the risks and benefits of various types of treatments so that you can make an educated guess as to whether you want to do A or B or nothing. That's an option that has to be presented. And that test is whether a reasonable patient received appropriate information so that he or she can make a reasoned decision as to what the appropriate care is. Then if things go wrong and you have been told about the possibility that these things can happen, then you don't have a claim.
No.
But if you're not told about a potential result, and not just any result, but ones that are known to be more than 1 in a million, and you decide to go forward with that, and something bad happens, you don't have a claim. But if you're not told about something that is known to occur on a more than, as I say, 1 in a million time, then you've got a claim for a lack of informed consent, and that doesn't require an expert.
Okay.
And it doesn't require negligent conduct.
Now, when you're sitting, say I'm sitting with a doctor, he's informing me of this, does he have you sign something?
Some do. Because of the breadth of the informed consent claims and the ability of patients to establish those without experts, and it becomes a he said, she said many times.
Yes, that's what I was going to say.
Doctors either write it in the records, which they're required to do, or in hospitals, for example, you actually sign a form which sets out what the procedure is, what the risks and benefits are, and then you sign that you've acknowledged it. Some doctors just do it verbally, and then they're sorry later on because they say, well, I told the patient that this could happen, and the patient said, no, you never told me that. Or I told the patient they had this option versus this option, and the patient says, no, they didn't. The doctor told me I had to have this procedure. So I advise all of my clients, it may take an extra 10 minutes, and the patient may say, well, why are you making me sign it? I said, you'll be sorry if you don't somewhere down the road.
Okay. And then the patient
and
needs
you have to
take...
use lay language.
Yes.
You can't use medical terms that a patient won't understand. So it's a difficult requirement for physicians, but they've learned how to do it.
Yeah, that's good. Because, the he said, she said just doesn't hold water at all.
Then it's up to the jury to decide who's telling the truth. And
right.
That's a roll of the dice.
And typically you have a jury when you go.
Almost everyone wants a jury. If you have a claim against a state hospital or AAA, for example, those are judge-decided cases.
Okay.
You're not entitled to a jury.
We're going to wrap it up with Mr. Jeff Portnoy, and I thank you so much because you just uncovered in this short period of time what I think most people don't know. Because like I say in my show, the motto is, it's not a matter of if, but it's a matter of when you may need, legal advice. And I think a lot of people feel, if the results, we're saying, I just went to the doctor and I'm suffering, I'm in pain. That's what I generally hear. Why did the doctor do this, do that? But you just cleared what doesn't.
Yeah, and I want to make this clear that, unlike almost every other time someone gets injured and thinks they have a claim, in the medical field you have to go through this administrative proceeding. And I don't want to discourage anybody from doing that. You can do that on your own. It's not all that expensive. There's none of the discovery that goes on in court. You just go before a lawyer and a doctor in this session in an office building in a conference room, and those two people will decide whether, not decide, but they will help the parties understand each other. And sometimes that's really good. Sometimes, one of the major reasons people bring medical negligence cases is because they haven't felt that they've been treated appropriately by their doctor. I'm not talking about the medical part of it. I'm talking about the conversational part of it.
The relationship.
The bedside manner.
Exactly. I hear a lot about the bedside manner.
Sure.
And sometimes that alone might make them feel he didn't treat me right.
Absolutely.
Because people are human. They have feelings.
And I tell doctors all the time, you need to sit down with people who are unhappy and explain what happened. That may not satisfy them, but many times that will. And so when you go to this proceeding, the MICP, sometimes that's accomplished. The doctor will talk to the patient who brings the claim and explain things. Or the doctor on the panel will explain to the patient, gee, I know you're unhappy about this, but I can tell you from my experience that there isn't any negligence. Or we'll tell the doctor, you know what, Dr. X, I think you got a problem here. You may want to think about resolving it. So that part of it, I don't think people should be discouraged. But if you're going to file a lawsuit, you need to make sure that you have a good lawyer and that that lawyer has spoken to a very respected expert to say you have a legitimate claim. It may not wind up being that, but at least someone who knows the medicine needs to tell you that the doctor you're angry at has done something that another doctor in the same situation not only wouldn't have done, but most doctors would have done it differently.
Now, real quickly before we end here, there is a statute of limitations.
Yeah, and it's a little bit complicated, but to be safe, it's 2 years from when the Negligent Act took place. But it can be extended by what's called the discovery rule that brings into the equation when you knew or should have known. And there are questions about whether you have to have an expert tell you have a claim or not, but I will tell people to be absolutely safe, if you have a claim, you need to bring it before the MICP within 2 years of when the Negligent Act took place. It can be extended. You may not know about it. For example, a doctor may leave a device in your chest. You have no idea until 6 months later it starts to hurt. Well, then it'll be extended, but that's a little risky. So I would use the 2 years on my calendar if I thought I had a claim.
Okay, and it's best to, I'd say, if you're going to go through any procedure, especially major one, take notes, right? Take a diary.
Yeah, you know, look, I think most people trust their doctors. They're still one of the most respected professions. You have to hope the doctor's notes are accurate. That's another thing you want to do if you're going to pursue a claim, is ask for your records. You're entitled to your records. The doctor has to give you your records. The hospital has to give you your records. And then you present them to an expert or to a lawyer to look at. But you need to have somebody review the records. I want to say this just to make sure that, you know, I'm not giving legal advice per se, just kind of talking in generality. So if you think you have a claim, you need to get a lawyer to tell you what your rights are.
Okay.
So we've just talked generally about things, and I have
yeah.
no problem with that. But people need to get an association with an attorney to find out exactly what their rights are in this area.
All right. Well, fantastic. I think you just gave us in a short amount of time some really, really great nuggets, and I thank you so much.
No problem. It was great.
And in the video part, we shaka out as usual.
Shaka out.
And in the audio part, we say aloha.
Aloha.
And a hui ho.
A hui ho. Bye.
Bye.
Thank you for listening to the Legal Advice in Paradise podcast. For more information, visit www.legaladviceinparadise.com.